Eric, your mic is on.
Okay.
What are you asking for?
Just asking her to keep the bond Siegel set in place.
Okay. But he lives out of state. How do you do pretrial release?
Oh no, if she wants to modify that, I'm just asking about the bond.
You don't care about the pretrial release?
I don't know that Siegel, he can't put a GPS, she can't do a GPS of him living out of state, and I don't know that Siegel even knew that he was, permanently living out of state.
So you have no objection. Just straight 75.
Yeah, fine with that, no contact.
All right, good morning, everybody. You are in First Appearance Magistrate Court. My name is Kim Teresa Malika. Today you will be informed of the charges, and we're going to determine if there's probable cause. Today is not your trial date. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. You also have a right to an attorney. There's a public defender at the main jail, and we have Mr. Reedy, who's over here to my right in the courtroom. If you have a private attorney, immediately when you step up to the podium, please let me know. We're going to call a couple cases at a turn at the request of the jail. And the first one is going to be Christian Rivera, page 1 of the docket.
Mr. Rivera, here at the Judge.
All right. Good morning, Mr. Romero. How are you?
Good morning, Judge.
All right. And we have Mr. Linder from State Attorney's Office over here as well. Okay, Mr. Rivera, you have an out-of-state hold for a felony out of Pennsylvania. You're going to be held no bond. We'll see you in extradition court Tuesday or Thursday at 1 p.m., okay? Good luck to you, sir.
Thank you.
You're welcome. Next one, Raul Di Casanova, please.
Yes.
Good morning, sir. How are you? Page 6 of the docket, Mr. Romero.
Yes, thank you, Judge.
You're welcome. Okay, Mr. Di Casanova, you have trespassing unoccupied structure or conveyance. Bond's been set at $25. The court does find probable cause. Court's going to order no return, sir, to 9380 Sunrise Lakes, apartment 101, Sunrise, Florida. Do you understand?
Yes, ma'am.
I believe that's your father's home. So, can you afford the $25 bond?
No, ma'am.
All right.
Judge, he wishes to ask the court if you would consider resolving his case today for time served.
You know what? I'm not inclined to do that just because of the circumstances, but I'll tell you what, ROR, or I can put him on free trial. I mean,
No, we
I don't mean
he does have a separate place to reside. He has no problem abiding by the court's order for no contact.
All right, let's see what the state thinks.
As far as,
ROR or standard pretrial release?
well, if I had to choose, I would ask for, did the court mean bond or pretrial release?
No.
Well, then I'd ask for pretrial as opposed to ROR.
Okay. All right, so the court's going to put him on standard pretrial release. Sir, is your address 6151 Southwest 41st Place, Davie? Is that where you get your mail?
Yes, ma'am.
All right, thank you very much, sir. You have to report within 24 hours, okay?
Are they gonna let me out today?
They should let you out today.
Thank you, ma'am.
Sir, if you don't show up to court, sir,
Come on. Yes, ma'am.
if you don't show up to court, you're gonna have a warrant for your arrest, and then you're gonna get violated on your pretrial, and then the bond's gonna be set. Do you understand?
Yes, ma'am.
Look for your court date. All right, next one is George Sontag on page 7 of the docket, please.
Judge, he's approaching. These are, I believe, all uniform cases.
Yes, they are. Mr. Sontag, how are you, sir?
Fine.
All right, sir, you have 20 different multiple charges. Bond set at different amounts, so let's go through what they are.
I came to court last week and they dismissed the charges. The judge.
Dismissed the charge, how many charges?
Huh?
How many charges?
Gave me time served.
For how many charges?
I don't know.
Well, let me just go through this. What did you plead to?
I have 22.
You have 20 charges. You have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. You have 12 carrying open containers. Bond set at $100 on each one. Then you have lodging on property without consent of the owner. You have $200 bond on one, $100 bond on another, $100 bond on another, $100 bond, and $100 bond. Then you have sleeping on a public street, $100 bond. You have trespass of private property, $100 bond. And trespass private property, $100 bond. So I'll tell you what, sir, I'll, later on today, look up these cases, and, you'll be going before your division judge. Something's going on here, you got a lot of charges, and, you'll be in court fairly quickly, okay?
I don't understand how they released me, and the judge said,
We'll look into the charges, sir, okay?
huh?
We'll look into the charges, sir. Thank you. All right, we got this case right here, this guy. Okay, just mark it and we'll talk about it later. Gilbert Hinton, please. Page 8 of a docket.
I believe he's also a municipal in his case, Judge.
Yeah. This is a Fort Lauderdale one. All right, we'll recall Mr. Hinton.
Yes, ma'am.
You have a trespass after warning. You keep seeming to go back to I-95 and Davie Boulevard.
No, ma'am. Do I need to do what, ma'am?
Okay, hold on, let me just see. Hold on. All right, we're gonna recall your case and wait for Mr. McLawrence, okay?
What do I?
Just have a seat, sir, we'll get back to you. All right. Joshua Lapatis, page 12 of the docket.
Thank you, Judge. He's approaching.
Okay,
Come on up, Mr. Lapidus. Trying to see.
Michelle, we need to pull these two cases for private.
Your Honor, it's my understanding Mr. Lapatis has a private attorney, Mr. Eric Clayman, who I'm trying to reach. If Mr. Lapatis has the phone number for Mr. Clayman, that would make things a lot
Yes, I
easier.
do.
Can you give it to Hector, and then he can give it to me, and I'll call him?
I'll just give it to you right now. What is it?
All right.
It's 954
Okay.
218 9140. 9140.
Wait, 954.
218 9140.
Okay, I'll give him a call.
Thank you. Thanks. Have a seat, sir. Yep, they're going to try and contact your attorney.
Okay, next one is Michael Siminoff, please. Page 14 of a docket.
Mr. Seminoff, he's approaching, Judge.
Okay. Good morning, Mr. Siminoff. How are you, sir?
Good, ma'am. Good morning.
All right, sir, you have count 1, possession with intent to sell, manufacture, or deliver alprazolam, which is also known as Xanax, $1,000 bond. You also have possession with intent to sell, manufacture, or deliver heroin, $2,500 bond. Possession with intent to sell, manufacture, or deliver oxycodone, $2,500 bond. I'm sorry, the bonds are $1,000, $2,500, and $2,500. Count 4 is possession of cannabis over 20 grams, $1,000 bond, sir. Count 5, possession of controlled substance without prescription, $1,000 bond. And count 6 is a habeas misdemeanor with a $50 bond, and that's for an unlawful license tag sticker attached. Okay. No, that's fine. What's this one? Where do you want me to put this? On top or the bottom? Okay, all right, thank you. Thank you, Sheila. All right, so let's start from the top again, sir. These are these ad charges?
It's the same charge, they just have one or two on.
Okay, improper, count charge 7 is improper stop or stand, or park. That's actually a civil traffic infraction. And count 8 is a drug paraphernalia, possess and or use.
Thank you, ma'am.
$100 bond. Anybody wish to be heard?
Yes, Judge, and Mr. Sentinel, he's gonna be relying on his, mother and his wife to help post his monetary bond. My understanding, Judge, is, he's 25 years old. He's been here since he was a child, about 14 years old. He is working. He works for a company called Solomon's Construction. He's a heavy equipment operator. He's been doing that for quite some time, making about $17 an hour. He's the sole supporter of his family, his wife, and his 3 children. They live in Deerfield. Their monthly rent is about $1,100 per month. Judge, he can afford some bond, but we're going to be asking a bond reduction specifically on counts 2 and 3. We'd be asking for $1,000 bond on count 2, $1,000 bond on 3. We believe that would be reasonable under these circumstances, Judge.
I'm fine with that.
Okay, so. All right, so the court will leave all bonds in place, except for 2 and 3, I'm gonna change to $1,000 each. Do you need me to repeat them all, Sheila?
No, I haven't.
All right,
Judge,
thank you very much, sir. Let me just verify your address.
your address is going to read it right now.
1970
See if it tells us correct.
1977 Southwest 15th Street, apartment 105, Deerfield.
Yeah.
All right, sir, good luck to you.
Good luck, sir.
Okay. That was Seminole, right? Okay. Anthony Garcia, page 14 of a docket, please.
Mr. Garcia, come on up, please.
Okay, Mr. Garcia, you have grand theft between $300 and $5,000. Court does find probable cause. Court is going to order, sir, no return to the target located at 3599 West Hillsborough Boulevard. Do you understand, sir?
Yes, sir. Yes, ma'am.
All right, so bond is grand theft $1,000, possession of heroin $1,000, and the warrant for VOP pretrial is not for magistrate. You have a no bond hold. Anybody want to be heard on counts 1 and 2?
Considering Judge he has a no bond hold, we'll be deferring our argument so it can be heard in front of his division judge.
Okay, so $999 on 1 and 2 each, okay? Thank you, sir. Next one is Christopher Cambron, page 17 of the docket, please.
What page, Judge?
17.
Thank you.
You're welcome.
Mr. Cameron, come on up, please.
Good morning, Mr. Cambron. How are you, sir?
Making it.
Okay. All right, sir, you have petty theft, second degree, first offense, $25 bond. You do have an out-of-state hold for a felony for a violation of a parole to Tennessee for aggravated robbery, 3 counts. Do we know if this petty theft is a result, or the parole violation is a result of this petty theft, I should say? Does anybody know? $25
Probably
bond?
not, Judge, because it was,
Huh?
there was, probably not, because there was a hit confirmation from Tennessee.
All right, so what are we doing with this? Hi, Craig.
Morning, Judge.
Pat. I'm sorry, Pat. I always do that, sorry. Okay, so what do you want to do with the $25 bond, folks?
Just ask that it be left alone, Your Honor. He gets out of state. He's not going anywhere until it's ultimately resolved one way or another.
Want to be heard, Mr. Romero?
No, Judge, right now, if he tries to resolve it or anything like that, it might go ahead and have negative impact on him. Judge, if I ask you for an ROR, at this time, he's not gonna go anywhere, and he's not getting any sort of gain time, so that would hinder him as well, so at this time, we'd ask you to leave it alone, Judge.
All right, no return to the Walmart, 2551 East Hallandale Beach Boulevard. Court will do a $1 bond on count 1. Thank you, sir. Good luck to you. Okay, next one is gonna be Aaron Chalancini,
Judge, she's approaching, Judge. She declined the services of public defender.
Okay, page 19. Good morning. Are you Aaron Chalison?
Yes.
Did I say that right, sir?
Shalonson.
Okay, Chalonson, I'm sorry, sir. You have count 1, possession of heroin, $1,000 bond. Count 2, resisting an officer without violence, $100 bond. Count 3, tamper with or fabricate physical evidence, $1,000 bond. And bike regulation violations, which is basically a civil traffic infraction. It's not for magistrate court. Court does find probable cause. Can you make the $2,100 in bond, sir?
Yeah.
You can? Okay, thank you very much, sir. Good luck to you. Next one's gonna be Edward Zamora. And give me the
Mr.
That's-
Zamora, come on up.
page 20 of the docket, Mr. Romero.
Thank you.
You're welcome. Good morning, Mr. Zamora. How are you, sir?
I'm good, Your Honor.
All right. All right, sir. You have a petty theft, $500 bond, trespass private property, $100 bond. You have battery on an emergency medical care provider, which is a no bond hold, and you have a trespass structure or conveyance is also a no bond hold. Let me just look. You no-showed in front of Judge Lynch on May 31st. So anybody want to be heard with regard to the $500 or the $100 bond on the 2 capious misdemeanors?
Post-its, please.
Can't hear you, Mr. Romero.
Judge, I know count 2 is the municipal ordinance, so I have no input as far as that. Let me talk to.
Oh, you are correct. Let me.
On count 1. But you can't release it, you have no bond. Judge, at this time, he's not going anywhere, unfortunately. He told me there's no way he can afford to post a monetary bond, but I told him even if the court were to ROR you, he's not gonna get out, so he's not gonna get credit, so at this time,
Okay, count 1, $499. Count 2, $1. Thank you, sir. Good luck to you. Okay, then we have 2 other private attorneys. We have Alexander Sass, page 19 of the docket.
Mr. Sass, your attorney, I believe
Thank you
that's
for
Mr.
your
Greenwald.
patience.
Gerald
Thank you
Greenwald.
for your patience.
Morning, Your Honor.
Good morning, how are you?
Very well. I'm Brian Greenwald on behalf of Mr. Sass.
Okay, give me one moment. All right, Mr. Sass, how are you this morning, sir?
I'm good, Your Honor, how are you?
Fine, thank you. All right, you have a warrant for a felony battery. Court does find probable cause. Bond set at $1,500.
7,500, Your Honor.
Is it? It looks like.
Judge, I would ask for actually a
Yes,
reduction.
it is $7,500.
Mr. Sass, I don't believe has
Thanks,
any
Eric.
prior convictions. In addition, the probable cause, I'm not objecting to the court finding probable cause, but just reading the facts of this case aren't the most egregious. It was a push, and the victim, after being pushed, allegedly hit a concrete pillar and had some damage to his eye. So with regards to the $7,500, I think that's a little high. I'd be asking for $2,500. And I believe, in addition, they might have put pretrial release on there. Mr. Sass lives out of state, and the pretrial release is going to be almost impossible to comply with. In addition, he hired local counsel, the lack of any prior criminal history. I would ask that the court just leave bond at $2,500. I did talk with the state earlier this morning. We didn't have an agreement as to the monetary bond amount. I think the state still wants to keep it at $7,500, but my understanding is Mr. Linder doesn't have any objection to deleting the pretrial requirement.
State, what's the initials of the alleged victim?
They are BC.
One person?
Yes.
All right, sir, you're going to have no contact, direct or indirect, with the alleged victim in this case. Do you understand?
Yes, Your Honor.
And I want everybody to listen up. Direct or indirect, no contact. Direct or indirect means no contact in person, calling, texting, writing, nothing on social media, liking, disliking, and no contact through third parties, okay?
Yes.
All right. All right, so, let me just verify. So you're gonna put your appearance in?
Oh, I couldn't earlier, only because the case was sealed until he actually got here to Broward County, so I didn't have a case number.
Okay.
But I've been
But you're
representing
going
Mr.
to.
Sass for the past week now.
All right, as long as you tell me you're going to. I'll
Yes,
take
Your Honor.
Face value. All right, sir, is your address 32 Canfield Road, Parish, New York,
Yes, Your Honor.
13131?
Correct.
All right. All right, the court's gonna do $2,500.
Your Honor?
Yes,
Is the court going to allow the state to have an opportunity?
sure.
Your Honor, I'm asking that the court keep the bond at $7,500. My concern is his future appearance in court. As you stated his address, he doesn't reside in Florida. He had to be extradited here from New York. He has a warrant out of Dade County for failing to appear in a traffic matter. He also has an open leaving the scene of an accident. Just that offense in its very nature gives me concern that he will not show up in court. I mentioned to counsel that I don't have a problem with the court taking the GPS monitor off if the $7,500 bond is kept in place, because I believe that would be an appropriate amount to ensure his future appearance in court.
Okay.
I understand the state's concerns, but again, I stand firm with regards to the facts of the case. It was a push, and only because of the injuries the victim received, obviously the state has every opportunity to file this as a felony battery. I'm going to be resolving all of Mr. Sass's issues, and if the court has concerns with regards to the monetary amount, I would just ask that the court split the difference. And I talked to his family, and they'd be able to afford up to a $5,000, but anything more is going to be a little burdensome in order to post. And
$3,500 bond, thank you.
I'm sorry?
3,500.
3,500. Thank you,
Thank
Judge.
you.
Excuse me,
Thank you.
are you deleting
Oh.
the pretrial GPS?
Yes.
He needs to do an order deleting the pretrial GPS because it was in the warrant.
I'm sorry?
You would need to do an order
Okay.
that the conditions of the pretrial GPS has been deleted.
Do you want me to write up a short order?
Yes,
I can
so
do
she
that.
could sign it because it's.
And
in the
as long as Mr. Sass is here for his benefit, your family sent me your telephone and wallet, so just call me when you get out, and we'll get that to you.
Sounds like a plan.
Okay.
Thank you.
All right, let's go off the record for a moment. Powers to be.
Okay.
Okay. Fabrice Lorenz Duncton, please.
Good
morning, Your Honor. How are you this morning?
Good. What page is this on the docket?
I apologize, I didn't look at the 16.
Page 16 of the docket.
Judge, Mr. Duncton's there. His father was on his way. I don't see him right now, but I can,
We can recall it if
no,
you'd
it's
like.
okay. I can tell you a little bit about this. I've been on this
Well, let me
case
just start,
since,
Mr. Weeks,
sure.
if you give me a moment. Are you Mr. Fabrice Lorenz Duncton?
Yes, ma'am.
All right, we have your private attorney here, Mr. Weeks. You have count 1, 2, and 3. Aggravated fleeing with serious injury or death. We need to talk about bond. Count 4 is fleeing or attempting to elude a law enforcement officer, $1,000 bond. Count 5 is vehicular homicide, failed to give info and render aid. We need to talk about bond. Count 6 is possess with intent to sell, manufacture, or deliver cannabis, $1,000 bond. And count 7 and 8 they have as no bond holds, which is reckless driving, damage person or property, 2 counts of that. And then we have a count 9, resisting an officer or obstructing without violence. Any objection to probable cause, Mr. Weeks?
No, Judge.
Okay, the court does find probable cause. State?
Judge, thank you. On December
Can you
2nd,
announce your appearance for the record?
I apologize.
That's
Veronica
okay.
Rivera, Traffic Homicide Unit, State Attorney's Office.
Good morning.
Good morning, Judge. On December 2nd, 2017, the defendant did flee. He had in his vehicle Miss Abigail Espinoza as the passenger. As he fled, Judge, he fled an officer who had observed a alcohol bottle in his vehicle, had observed a mason jar of cannabis in the defendant's lap as he was behind the driver's side steering wheel.
Is this all in the probable cause affidavit or the warrant?
Judge, may I approach?
Sure.
There are actually two probable cause affidavits.
Did you provide one to counsel?
I just showed it to him this morning.
Okay, thank you.
There's also additional supplemental reports.
Okay. So let me ask you this. I hate to do this, but can we recall this and just give me a moment to read this?
Sure,
or-
Judge.
Sure, Judge, and I'm also going to go with that I have as well.
Okay. All right.
And I apologize, it was two different jurisdictions, and I believe the court only got one.
No, that's fine. I'm not, thank you. All right, so we're going to take a brief recess. Let me just read this. for your patience.
No problem, Judge. Again, Veronica Rivera for the state. As the court was reading, the defendant then fled. He fled. Coconut Creek police officers, numerous police officers attempted to pull the defendant over. As he continued to flee and the officers were getting closer to him to conduct a felony stop, the defendant U-turned illegally into oncoming traffic. He continued to flee then in the other direction where he disobeyed a red light. He was visually estimated to be traveling about 100 miles per hour in a 40-mile-per-hour road. He turned onto Rock Island Road, which is a winding road. There are residential homes and apartments in the area. After proceeding down that road, he did lose control of the vehicle, drove into oncoming traffic, through into the opposite lane, and he did strike another vehicle. That vehicle smashed the passenger side of the defendant's vehicle as the defendant crashed into the other vehicle, which was traveling lawfully at a lawful speed. I have provided photos to Your Honor showing the crash. That crash ultimately killed the passenger, Miss Espinoza. The defendant, the vehicle he was driving was shown through the EDR to be traveling at 92 miles per hour, 5 seconds before the crash. And once the vehicle was searched, the officers did find just under 2 pounds of cannabis in the defendant's vehicle. Additionally, as far as priors, Judge, the defendant was actually in drug court on a felony drug case during the time of this incident. He then did plea that out, a possession of cannabis and resisting without violence. That was pled out in December 13th, 2017, but that was a pending case at the time. As far as additional priors, he has a 2016 possession of cannabis and drug paraphernalia. He also has a 2014 resisting without violence and possession of drug paraphernalia, and a 2014 aggravated battery. Judge of the state
What
does...
happened, what was the disposition of the aggravated battery?
The aggravated battery was a withhold as a juvenile.
Okay.
The state does believe that the defendant is a threat to the safety of the community. He was fleeing officers, numerous officers, in 2 different jurisdictions at the time of this crash. Fleeing is obviously 4 charges in this case.
What is the bond you're requesting in this case?
Judge, the bond I'm requesting is $75,000 on counts 1, 2, and 3, as well as the vehicular homicide.
So 1, 2, 3,
and 5, as well as $10,000 on the aggravated fleeing and eluding count 4.
Hold on, count 4. I'm sorry, how much?
$10,000. And $5,000 on count 6, the possession of cannabis with intent to sell. And the state would ask the court to also consider, as part of the factors, factor F, the source of funds used to post bail, and factor H, the street value of any drugs or controlled substance, because he is charged with a intent to sell crime. The state would also ask that the bond be fully collateralized. If he were able to post bond, he is placed on a pretrial level 1 with a GPS, as well as no driving, no drugs or alcohol with random testing, and to surrender his passport if he has one and not to apply for one.
Excuse me.
Yes.
Count 7 and 8, I'm gonna give you a copy of the booking sheet. 7 and 8 was booked as no bond, but per the capias, it should have been hold for magistrate for bond to be set by you.
Okay. So it should have been HG.
Yes.
I'll just change it on my top sheet.
Okay.
Okay, anything further, state?
Nothing further from the state, Judge.
There's a lot to talk about this case, Judge. The first thing I needed to talk about, which you don't see in any of these reports that I think is extremely concerning, is the fact that, yes, Mr. Ducton was currently in drug court, He was in front of Judge Tobin Singer. Mr. Duckton then, as soon as he went to the hospital that night, his blood and urine and everything was collected. He was then court ordered to turn all that over to drug court to make sure that Mr. Duckton wasn't under the influence of any drugs or alcohol while he was in drug court. We had a little bit of an argument between Judge Tobin Singer and myself whether or not I should provide those documents, but that being said, those documents then were provided to the court along with provided by the state. I find it disconcerting that the state doesn't bring this to your attention, and I have to. But then he was found negative of all drugs and alcohol that night. So in every police report that you see that was done on December the 2nd of 2017, and even on these supplemental reports, it says that my client admitted to consuming alcohol. Then it says that my client was in possession of marijuana that was sitting in between his lap. And then the marijuana was actually supposedly, and I'm just guessing here, but it was found in the victim's backpack. So Judge, I would just take caution with these police reports that indicate that my client was drinking alcohol that night and that marijuana was found in this vehicle, and which is the reason for the stop. The police officer in this particular case is a Coconut Creek police officer, and he's been under investigation before for previous fleeing and eluding cases in which he chases down individuals. It's been all over the news in reference to those facts. So, Judge, candidly, coming into this court, I'm not sure what the state wanted to go forward with the charges that on. So if we can just attack each one of these charges. From counts 1, 2, and 3, aggravated fleeing and eluding, I guess that's for each particular officer. The only officer that I see that he aggravated flee and elude allegedly would be Officer Favata, F-A-V-A-T-A. That's the only one that indicates in the supplemental that he took off from. Initially, he takes off in count 4 from the initial officer in this particular case. So I'm not sure. And as the state indicated, numerous officers, I don't think we can just come in here and say, well, he took off from numerous officers, therefore, which hit him with counts 2 and 3. I think we have to have those officers and at least a report from those officers indicating that he took off from those officers. I don't see that at all. And so in reference, and I'm guessing what counts they are, but in reference to counts 2 and 3, I don't believe there's probable cause because I have no reference to any of these documents that indicate that he took off from Officer Bill, Jack, or Harry in reference to those particular counts. I'm not indicating, and at this point in time, I'm not indicating there was not some type of fleeing, Judge. But there is no DUI in this particular case. You could see for all this mention of alcohol in these cases, in every single police report that you see here, there's no reckless driving involved in DUI. There's no DUI involved. All his lab reports and everything that's been provided to the state attorney's office came back clean. He's been out on probation in front of Judge Fine since, I believe, the first week of, excuse me, I take that back, the 3rd week of December. He was kicked out of drug court because of these charges. So he's been watched and monitored. The victim in this case is his girlfriend, or was his girlfriend, Judge. So obviously, Mr. Duckton's been going through a lot emotionally in reference to that. He's not violated any terms of his probation. He has not been driving at all in reference to this probation. He's not a flight risk, and for the state to say that they believe that he's either a flight risk or a danger to the community, they haven't filed these charges for 5 months.
Did he turn himself in?
He did. He turned himself in last night at 5 o'clock, in which the state asked me, called me on Friday and said, can we have Mr. Duckton turn himself in? He voluntarily turned himself in. So for an individual that's either a flight risk or a danger to this community, for them to stand up here and say that, I found that a little bit disconcerting, concerning he turned himself in, and for 5 months now, the state attorney's office hasn't gone forward with the charges, and he's currently been out on probation. So, candidly speaking, Judge, his parents are here now in the courtroom. They're sitting in the front row. The state's asking for the monies in reference to the bonds. I guess, candidly, they're asking for a nebia to be looked at. His father's the one that's financially supporting his son right now. His son's being watched over by probation. I don't know how other ways we can watch it. I don't think pretrial release with an ankle monitor is going to watch him any more than his father, he's living at his house, and he's going through a lot. He has a 4-year minimum mandatory attached to this charge, right? So I would ask Kinley, Judge, for count 1, a $10,000 bond, no PC for counts 2 and 3. I would ask for count 5, a $20,000 bond, and collectively speaking, however the court wants to weigh it out, I think $50,000 a bond, Judge, where he's currently being watched by probation, and if the court wants to put him on pretrial release, I just think we're in itself we're kind of double dipping. I mean, he's being watched all over the place. So if I could take some quick testimony from his father, Judge, so you can hear a little bit about where the money would be coming from. But
sure, but let's resolve the State. What's your response to the no PC on 2 and 3?
Thank you, Judge.
And
First,
then we'll hear from his parents. I'll give you that opportunity. I'm sorry.
I like to point out in Mr. Weeks' argument that the defendant is not charged with a DUI or DUI manslaughter in this case. So bringing up the fact that there was cannabis in the defendant's vehicle, that is illegal. That has nothing to do with a DUI charge. He's not charged with DUI. He also did have alcohol in his car, and he's under the age, or he's not 21 yet. So all of that just goes to criminal activity. That does not go to say that the state is charging him with DUI, because we clearly have not. As far as PC, I did provide the court with supplemental reports from Officer Lewis.
Hold on, let me get it.
Sure.
Judge Canley,
You've seen these, right?
Yes.
I have supplemental reports, but I mean, I think the state needs to be a little bit more forthcoming with the court in reference to why they're not charging him with DUI.
No. I just, right now, let's just stick to the PC argument, and then we can go back to that if you'd like.
Thank you.
So, go ahead.
Yes, Judge. The report of Officer Lewis does state that he did activate his emergency lights and sirens as he was in pursuit of the defendant. Does give the area that he was at, and that the defendant made an abrupt U-turn near the 7500 block of Sample Road to avoid being stopped. I also have Officer Morales in a supplemental report. That is for count 4. In the third paragraph, Officer Morales discusses attempting to pull over the vehicle. He made his way to the front to attempt to protect other drivers. He began to slow down as he was the vehicle in front, attempting to conduct a felony stop. And the defendant evaded that as well. The last report, Officer Salazas. The third paragraph does state that that officer activated his emergency lights and sirens, attempted to stop the vehicle, and the defendant made an abrupt U-turn and fled. So I do believe that there are PC for all of those counts. The court obviously already has the PC from Officer Favada, and the defense counsel was not making argument as to that PC count.
So in other words, what the state's saying is that every single car was in the exact same position when this U-turn was made, and that they're asking for charges for every single police officer that was in a separate car. Judge, there's a lot going on in these PCs. I'll be candid with you. I mean, relatively speaking,
This is just a probable cause.
Judge, I understand, but I think it's really important for the court to know. I mean, even in the probable cause affidavit by Officer Morales, he indicates that the driver of the vehicle admitted that he'd been drinking alcohol. I wish the state would be candid with the court and tell the court that they have the lab reports and there's not an ounce of alcohol in my client's system. So I find these reports a little bit concerning to the court. I mean, granted, the police officers don't know on December 2nd, that my client's results for all these are going to come back negative. So they just put what they want to put in a police report, and they're almost identical to reference to this U-turn. It's disconcerting, Judge. So it's something that I think the court should take consideration of, and I think a $50,000 bond where he's currently on probation with living with his parents is appropriate.
And Judge, if I may also point out, when he did have that open case that defense counsel keeps stating he's currently on probation for, I did look that case up, and I did find that February 8th, 2017, there was a no-show capias for the defendant, which was withdrawn February 28th. There was also a no-show capias on that same case April 19th, 2017, that was withdrawn May 23rd, 2017. So there are PC for all of these charges to give the defendant the benefit of having a lower bond amount because he has violated the law previously and is currently on probation and had a pending case when these charges arose is honestly just a mockery of the court and the judicial process. I think $75,000 for the aggravating fleeing counts and the vehicular homicide is more than lenient in and of itself.
Judge, lastly, can I just take some testimony from his father, where he'd be living?
Anything further at this point? State?
At this point, no, unless something else comes up.
Okay. Go ahead. Okay,
State your
where's the
name
clerk?
first. Raise your right hand, okay?
If you, hold on, Madam Clerk, if you could.
Fedley Ducton,
Spell your last name, please.
Ductan.
Good morning, sir.
Good morning.
Mr. Ducton, are you the father to Fabrice Ducton?
Yes, I am.
Is he currently living with you?
Yes.
And where do you
yes.
currently live?
I live in 1804 Northwest 78th Ave in Margate.
Okay. And if the court was to place a bond in this particular case, what type of bond would you be able to afford in order to get your son out of jail today?
Well, whatever it is, I'll use my deed, my house to.
Understood. So in other words, you have a house that you have the mortgage for it and the deed of the
Yes.
house that you could put up in order to provide to get your son out of jail?
Yes.
Okay, and what has your son been doing from January till today's date? Has he been living at your house?
Still my house.
Okay.
Every day. Never.
He
been
does,
out.
he does not leave due to this case,
No.
correct? And those are the terms of probation that he agreed to?
Yes.
Judge, I have nothing further. Proceed.
If I could have just asked Mr. Ducton's father if the defendant was living with him at the time of this crash?
Yes.
I don't have any other questions for him.
All right, anything further from anybody?
No, Judge.
Judge, the only other thing I want to point out is the victim's family is present here in court today.
Okay, would they like to make a statement or anything?
I don't believe that they do, perhaps.
Victim advocate here?
Yes, she's present as well. State your name for the record.
My name is Juanita Diaz.
If we could have her to swear her in?
Say your name again.
My name is Juanita Diaz
Good morning.
Espinosa.
Okay.
And your relationship to the victim?
I am the mother of Abigail Espinosa.
And anything you want the judge to know?
As a mother, we've been through a lot of suffering, sorrow, and sadness because we love our beloved daughter in a crash victim accident. She was killed that day on December 2nd. Since that day, we've been in a sorrow and a sadness. As a mother, we claim justice. Thank you.
You're welcome, ma'am.
Nothing further, Judge. Thank you.
No, Judge.
Does your client have a passport? expired?
It's expired, but Judge, I can have him turn that in.
All right, this is what the court's gonna do. The court's gonna do $50,000 on one, $10,000 on two, $10,000 on three, $1,000 standard bond on four, count five, court's gonna do $10,000. Count six, court's gonna do 2,500. Counts 7 and 8, court's gonna do $5,000 each. And count 9, the standard bond is $1,000. Court's gonna do GPS level 2, no alcohol or intoxicants. He's to surrender his passport with the clerk and not possess and or apply for a passport, and he's not to apply for a passport card as well.
Judge, count 9 is a misdemeanor. Did you mean $100?
$100, I'm sorry, did I say 1,000?
Yes, ma'am.
Okay, $100 bond on 9, I'm sorry, that's the standard bond for the resisting without.
And Judge, no driving, is that a condition as well that court's imposing?
What's your position on no driving?
Give me 1 second, Judge.
Did you ask for that initially?
Yes, Judge.
Oh, I don't have it here.
Judge, we have no objection.
Okay, no driving.
Thank you, Judge.
Good
Thank
luck to you. Okay, Mr. McLawrence.
Yes, good morning,
Gilbert
Your Honor.
Hinton, good morning.
Judge
Our
Gilbert.
Spanish interpreter is also present, Judge.
All right, let's do Mr. McLawrence, and then we'll do, huh? No, I want them because they showed them to me in their reference, so they gotta be in the court file. Yeah, okay?
Judge Gilbert Hinton, he's on page 8 of the docket.
Yeah, and we have,
Veronica. Veronica.
all right, are you Mr. Hinton, sir?
Yes, ma'am.
All right, good morning, how are you?
I'm all right. Just a little messed up. Got in a little trouble.
Okay. All right, sir, well, you have trespass after warning, and I don't want you to respond to this, but apparently you keep going back to I-95 and the Davie overpass.
Judge, I read the PC and I discussed it with Mr. Hinton, and I didn't think that was an offense, walking over the overpass. I think correctively it should have been possibly a panhandling charge, but that's not the way the police officer charged it. Nonetheless, Judge, I discussed the matter with Mr. Hinton. He told me that he intends on going to BARC when he's released so he can get his ID and get his life in order. I did discuss with him the possibility of going to the Henderson Receiving Center. He told me he would rather do the BARC program on his own, but he does want to resolve this case, Your Honor.
You know what? This is what I'm gonna do. I'm gonna ROR him. He's gonna have to find a way. Let me just put here, he says he's going to BARC.
That's what he says, Judge.
Yes, ma'am. Do I push this button?
We can hear you fine, Mr. Hinton.
Okay. All right, I'm making a note on here, ROR, okay?
Okay. Mr. Hinton, what that means is you have to, you have my card, so you have to keep in touch with me so you know when your next court date will be. You'll have to appear in court.
He has no address. Do you have any address, sir, where you can get mail at all?
I'll get with my ex-girlfriend's grandma, and
Okay.
I'll get her address, and
All right, if you could update it, Mr. McLawrence, I'd appreciate it, okay?
I will get a hold of the lawyer there and give him the address.
All right, thank you.
Thank you, ma'am.
All right, anybody else? What about, We have someone, Joshua Lapidus. Did we ever speak about the private attorney, and then what do we have to?
I did speak with Mr. Clayman, Your Honor. He indicated to me that he does not represent Mr. Lapidus on these charges. He's willing to, but he's gonna have to have some further conversations with Mr. Lapidus first.
Okay.
So it appears we will be representing him this morning.
All right, all right. Are you Joshua Seth Lapidus, sir?
Yes, ma'am.
All right, sir. You have driving while license is suspended, a habitual $750 bond, motorcycle without eye protection, not for magistrate. You do have counts 3 and 4, which are no bond holds, probation violations, and count 5 is a capias for traffic for operating with a suspended driver's license, second offense. Court does find probable cause. You are going before your division judge, Judge Edward Merrigan, on May 9th at 8:45 a.m. And on the capias traffic, the driving while license is suspended, you're going May 10th, and that's before Judge Robert Diaz at 11 a.m. Anybody wish to be heard?
No, Judge, considering he has no bond holds in their VOPs.
Pardon?
No, Judge, considering their VOPs and he has a no bond hold.
Okay, so $749. Let me just check his address. So it has at large. Does he have a mailing address?
Do you have a mailing address? We have 401
Hold on.
Southeast 19th Ave,
401 Southeast 19th Ave.
Pompano Beach, Florida. 33060, apartment number 7.
Michelle. All right, 700. Oh, I'm sorry. And on count 5 is $499. Thank you. I gave you everything. Everything's there. I need them attached because you referenced them. Okay, so if you want a copy of them, Michelle can gladly make you one. Is that what you want? Because I want the pictures. Okay, the pictures have to stay in evidence because you referred to them. Okay, there you go. Oh, let me see that again. Sorry, can you put that back? Okay, you know, state, people can get a passport card. So you gotta start including the passport card in here, okay? So if you could come here and I'll give it back, include the card in here. He doesn't have to surrender the card, but we didn't ask him about that, but you should put it in there, okay? All right, Spanish interpreter. Fiorella Arcel Palomino,
Yes, Your Honor, she's in Paul Ryan.
okay?
She speaks English, but she felt more comfortable if we had a Spanish interpreter present
Sure.
for her.
And I heard that our summer intern's here. Hi, we'll be with you in 1 second, right after this case, okay? We'll take a fast break. All right.
I don't know how Ms. Arce Palomino wants to proceed this morning. We weren't
All right,
able to
let
get
me
that
just-
far.
All right. Raise your right hand. Do you swear and/or affirm to translate from Spanish to English, English to Spanish to the best of your ability?
I do. Good morning, Your Honor. Solange Sands, S-A-E-N-Z.
Hi. Did you
Hi.
have a nice weekend?
Yes, I did. Thank you, Your Honor. Great here.
Oh,
Very
thank you.
nice.
Thank you. All right, so are you Miss Fiorella Arce Palomino?
¿Usted es la señorita Fiorella Arce Palomino?
Sí.
Yes.
All right, ma'am, you're charged with operating without a valid driver's license.
A usted se le acusa de conducir sin tener una licencia válida.
Bond set at $250.
Va a tener una fianza de $250.
Is your address 9011
Su dirección es la 9011,
Northwest 38th Drive, Coral Springs?
es Northwest 38 Drive in Coral Springs?
Correcto.
Correct.
All right, defense, you want to inquire about anything? You said you didn't have an opportunity to speak to her. I thought that at least is what you were going to say.
Vamos a ver qué dice la defensa porque no ha tenido oportunidad de conversar con la señorita todavía.
Yes, Your Honor. I do not know if Ms. Arce can afford to make a $250 bond.
Señoría, no estamos seguros si la señorita puede pagar la fianza de $250.
So I would ask, can she afford that bond?
Eso sería la pregunta. ¿Usted se le hace posible pagar esa cantidad?
No.
Is there anyone
No.
is there anyone I can call to come bond you out?
¿Habría alguna persona que podríamos llamar para que le vinieran a pagar esa fianza?
Lamentablemente en este momento no tengo el número telefónico de ninguna persona.
Unfortunately, at this time I don't have anyone's phone number.
Where are the phone numbers?
¿Dónde tiene sus números?
En mi teléfono, en mi casa.
They're in my phone. My phone is at home.
Oh, okay. How long have you lived at this address in Coral Springs?
¿Cuánto tiempo tiene viviendo en esta dirección de Coral Springs?
Más o menos 10 meses.
Around 10 months.
Who do you live with?
¿Con quién vive ahí?
Con mi roommate, Laura Cortés.
With my roommate, Laura Cortés.
What are you asking for, Mr. Reedy?
I'm asking for an ROR, Judge.
Bueno, entonces pediríamos que quede en libertad bajo su propia palabra.
Judge Schiff issued a capias. He didn't show up in court.
Okay. Does she want to resolve her case today?
Tenemos orden de arresto porque ella no compareció a la fecha anterior. Vamos a ver si quiere aceptar una negociación con el Estado. Okay.
Is the court making an offer, or is the state making an offer?
State's offers withhold court costs.
La oferta que le hacen es retención de fallo y pagar los gastos del tribunal.
Ms. Arce,
Señora o señorita Arce,
if you're willing to give up your right to a trial
si usted está de acuerdo a renunciar a su derecho de celebrar juicio
and enter a plea of no contest,
y declararse que usted no disputa los cargos,
the court will withhold adjudication,
el tribunal le daría retención de fallo,
which means you would not have a conviction for this on your record,
y eso quiere decir que no queda registrada su condena en los antecedentes,
and you would pay court costs,
y usted pagaría los gastos del tribunal,
and you'd be out of jail today.
y podría salir de la cárcel hoy mismo.
But you cannot drive until you get your driving license straightened out.
Pero le queda prohibido conducir hasta que consiga una licencia válida.
If you continue to drive
Si usted vuelve a conducir o sigue conduciendo
and you get convicted for a third time of driving without a license,
y se le vuelve a condenar de conducir sin tener licencia por tercera vez,
you could lose your license for a lengthy period of time,
le podrían o quitar el beneficio de conseguir una licencia por un largo tiempo.
and you could also be charged with a felony.
Y también se le podría acusar de un delito de grado mayor.
So please get your license straightened out
Así que por favor arregle sus asuntos con la licencia
before you get behind the wheel of a car.
antes de volver a conducir.
Okay?
¿Ok?
All right. Would you
Yes,
like to,
I agree.
Okay. Would you like to take the offer that's been extended by the state?
¿Usted quisiera aceptar la oferta que le ha hecho el Estado?
Sí, ¿cuánto sería el costo?
Yes, I would. How much would I need to pay?
$293.
$293.
Ok. ¿Cómo haría el pago? ¿Dónde haría el pago para poder salir hoy?
Okay, good. But where would I need to pay? Like, how do I make that payment so I can get out today?
You're going to be released today, either way.
Va a quedar en libertad hoy, sí o sí.
But you will have 90 days to pay the clerk's office.
Y le van a dar 90 días para pagar esa cantidad con la secretaria de la corte.
If you need more time, you'll have to write them a letter asking for more time.
Si necesita más tiempo, le puede escribir una carta a la secretaria y pedir más tiempo.
She can also pay online if she
That's true. As the judge says, you can also pay online.
También es posible, si usted quiere, entra en la página web y paga por internet.
And I think she might be able to make partial payments as well. I'm not 100% sure.
También le permiten pagar de a poquito si es necesario. Okay.
Raise your right hand.
Ahora levante su mano derecha.
Right, that's left.
Your other right hand.
Esa es la izquierda, la derecha.
Do you swear and/or affirm to tell the truth?
¿Jura y confirma que nos dirá la verdad?
Sí.
Yes.
Okay, you can put your hand down.
Ya puede bajar la
Is
mano.
your name Fiorola?
Su nombre es Fiorola.
And I'll spell your last name.
Fiorella.
A-R-C-E-P.
Le voy a deletrear el apellido que es A-R-C-E-P.
A-L.
A-L.
O-M-I-N-O.
O-M-I-N-I-O.
Okay, it's my understanding you wish to waive your right to a trial.
Tengo entendido que usted quiere renunciar a su derecho de celebrar juicio.
Anybody forcing you to do this?
¿Alguien le está obligando a hacer esto? No.
Are you under the influence of any drugs, alcohol, or medication?
¿Está usted bajo los efectos de las drogas, las bebidas alcohólicas o algún medicamento?
Ever been treated for a mental
No.
illness?
¿Y alguna vez ha recibido tratamientos para una enfermedad de salud mental? No, either.
You
Not either.
understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States.
¿Usted entiende que aceptar estas negociaciones pueden usarse en su contra en un proceso de deportación y también pueden afectar su capacidad de poder quedarse en los Estados Unidos?
Sí, entiendo eso.
Yes, I understand that.
Okay, understanding what I just explained to you, are you pleading guilty, not guilty, or no contest to operating without a valid driver's license?
Y al entender todo lo que hemos conversado, ¿cómo se declara usted? ¿Se declara culpable, no culpable o que no disputa los cargos en frente del cargo de conducir con una licencia, sin licencia válida?
Guilty, not guilty, or no contest?
¿Culpable, no culpable o no disputo los cargos?
No disputo los cargos.
No contest.
The court is going to accept your plea, find that it's freely and voluntarily entered.
El tribunal acepta su declaración. Vemos que lo ha hecho de su propia voluntad y voluntariamente.
The court has reviewed the court file and finds probable cause for the plea.
El tribunal ha revisado la carpeta de este caso y vemos que hay motivo fundado para aceptar esta declaración de culpabilidad negociada.
Court's going to withhold in court costs of $293.
El tribunal le otorga retención de fallo y le pedimos que pague gastos del tribunal $293.
You have 90 days to pay.
Tiene 90 días para pagar esto.
You have 30 days to appeal the sentence of the court.
Tiene 30 días para apelar la sentencia, la condena que ha dictado la corte.
If you can't afford an attorney, one will be appointed. Thank you. Good luck to you.
Si no puede pagar un abogado privado para la apelación, le pueden designar uno de la corte. Buena suerte.
Gracias.
Thank you.
You're welcome.
Con mucho gusto.
All right, you want to make an announcement?
I'll be happy to, Your Honor. ¿Alguien más necesita servicios del intérprete? Por favor, avisar a la persona que está a cargo.
Okay, anybody at the main jail need a Spanish interpreter? Mr. Romero? No? No response? No. Okay, anybody at North Broward need a Spanish interpreter?
No, ma'am.
Thank you. How are you?
Good, yourself?
Thank you. Anybody at Conti need a Spanish interpreter? No? How about Paul Ryan? Anybody need a Spanish interpreter? We did that just now. Okay. Thank you very much. Have a good day. See you
Good to
this
Your Honor.
afternoon, maybe.
Thank you very much.
Okay. All right, next one is Ryan Michael Burgeon.
Medical reset.
Next one is Sarisa Andre Ladera, please.
I believe bonded, Judge.
Okay. Stephanie Zaraga Danetta.
Bonded.
Renee Rashawn Keys.
North Broward, I believe.
Okay, thank you. Are you Renee Keys, ma'am?
Yes.
Ms. Keys would like to resolve this case if possible, Judge.
All right. Good morning, ma'am. You have petty theft, second degree, first offense. There's no bond attached to that. You have disorderly conduct, breach of the peace, no bond attached to that. You do have a resisting an officer or obstruction without violence. Court does find probable cause. Court is going to order no return to the family dollar store at 2711 West Sunrise Boulevard, Fort Lauderdale, Florida. If you go back there, ma'am, you'll be arrested. Do you understand?
Yes.
All right. State what's your offer?
Yeah, one moment, Your Honor. State's offered being adjudication time served on all counts.
Okay, adjudication time served.
Ms. Keys, would you like to accept the state's offer?
Time served?
Yes, adjudication of guilt and time served.
Yes.
Okay.
Okay, you want to explain to her that if she gets, or upon her getting her third one, they could charge it as a felony for a theft charge?
Ms. Keys and I have already had that conversation, Judge, and she is aware, just so it's on the record, that 2 more, you could get charged with a felony. You understand that, Ms. Keys?
Yes, sir.
Okay.
Or actually, if she had one before, it'll be her third one.
I think this is her first, according to the docket.
All right.
I wouldn't go by that.
All right, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
All right, put your hand down. Is your name Renee, R-E-N-A-E, Reshon, R-E-S-H-O-N, Keys, K-E-Y-E-S?
Yes.
It's my understanding you wish to waive your right to a trial?
Yes.
Is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness?
Yes, ma'am.
All right, don't tell me what your mental illness is, but does your mental illness affect your ability to understand what's going on here today?
No.
All right, you understand that upon you getting arrested, and if you get a third theft charge, the state can charge it as a felony even though it's a misdemeanor. Do you understand that?
Yes.
All right, understanding what I just explained to you. You want to plead guilty, not guilty, or no contest, and let me read the charges. Petty theft, second degree, first offense, disorderly conduct, breach of the peace, and count 3, resisting an officer or obstructing without violence. Guilty, not guilty, or no contest?
No contest.
The court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate you on each count and impose court costs on count 1, the petty theft, which I'm required to by law of $293. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. And no return to the Family Dollar Store, okay?
Okay.
Thank you, ma'am. Good luck to you.
Thank you.
Mary Cambron, please. Hello, Miss Cambron. How are you today, ma'am?
Okay, how are you?
Fine, thank you. All right, ma'am, you have petty theft, second degree, first offense, $25 bond. Count 2 is possession of buprenorphine. Have a hard time saying that, $1,000 bond. Count 3, ma'am, hold on, is possession of lorazepam, also known as Ativan, $1,000 bond. Court does find probable cause. Court's going to order no return, ma'am, to Walmart at 2551 East Hallandale Beach Boulevard, Hallandale, Florida. Do you understand, ma'am?
Yes, ma'am.
All right. Did you want to say something?
Judge, I had Miss Cameron listed as a person in the main jail, not in Pompano, so I did not ask to speak with her. Can you afford a $2,025 bond? Is there any?
No, I cannot, and I'm in a rehab. Those pills were mine.
Don't talk about the facts of the case this morning, Miss Cameron. Our main concern today is to try and find out if we're going to be able to get you out of jail. Is there anybody that I can contact that could come bond you out?
No, I have no one.
Where would you be living if you were released?
I live at 609 South Ocean Drive. It's a rehab.
What's the name of it?
Serenity Ranch.
Is that where you would be going back to?
Yes, sir.
How long have you been here in South Florida?
4 months.
Where are you from before that?
Tennessee. Knoxville.
Are you sure that Serenity Ranch will take you back?
Oh, yeah. I mean...
Have you spoken with them?
No. But, I mean, I know they'll take me back. I know the owner very well. I've been down here for 4 months. All my stuff is there, everything.
Judge, I understand from what Ms. Cameron's telling us that she may not have the strongest ties to the community, but she does have a place to go. I'd ask the court to consider releasing her on pretrial release and letting her go back to Serenity Ranch.
Dave, what's your position?
I'd ask that it be pending verification, no alcohol, intoxicants, random testing. She has a lengthy history out of the state of Tennessee for drug charges, theft, and failures to appear.
Who at Serenity Ranch can we get a hold of?
Al, his name is Al, but I don't know his number. It's in my phone.
Where's your phone?
It's at another jail, I guess. They took me from here to there, or from there to here.
Okay. All right. Judge, I don't know if you want to reset her for this afternoon. I'll try and contact Serenity Ranch and see if they're willing to take her back and speak to Al. Al?
Yeah, he's the owner. Or Mario. I can give you Mario's number, too. Mario Castura.
All right. If you have the number, give it to me. I'll call him.
I believe it is 954 434 9833.
Okay. How would you
We're
like?
gonna recall you this afternoon, ma'am. We'll see you at 1 o'clock, okay?
Thank you.
Okay.
Thank you, Judge.
Okay, Katie Daffin.
Judge, can you check count 3 for me, please?
Which
County,
one?
she was a reset from the weekend.
Who,
They-
Katie?
Yes.
Caddy?
Yes, count 3 should be a direct VOP. I think it says probation violation, or was it correct?
It says probation violation, no bond. Here, I'll show it to you.
Just attach that, Mr. Counsel. It should be put like that, direct VOP. It's a warrant.
So you don't mean a,
It's not a
948?
94806. No,
Not a 948?
no, ma'am.
Okay.
I don't even have this.
Thank you very much.
All right. Caddy Daffin, please.
Yeah, I don't have it either.
No, it's a recent.
But I don't have it.
We know where she is.
I'd love to tell you, Judge, but my computer is resting very comfortably on my dining room table right now.
Can pretrial or confinement tell me where Miss Caddy Daffin is?
She's actually a medical reset.
Loan?
Medical
Okay.
reset.
All right. Next one is Curtis Hunter, please.
North Broward.
Hunter would like to resolve this case this morning, if possible, Your Honor.
All right, good morning. Are you Mr. Hunter, sir?
Yes, ma'am. How you doing?
I'm
God,
doing fine.
God got a plan for you.
You got a prayer for me?
God got a plan for you.
Good.
All of y'all.
Okay, good. All right, sir. Count 1, trespassing, occupied structure or conveyance. $100 bond. Court does find probable cause. Court is going to order no return to 599 West Atlantic Boulevard, Pompano Beach. I don't know if that's the racetrack. It sounds like it.
Excuse me, Your Honor. They never gave me a warning for trespassing there. But I won't go back there. They never gave me a warning for trespassing there.
It says he repeatedly, sir, it says, and I don't want you to respond to this because you have an attorney here that's representing you, Mr. Reedy, but it does say, the court notes, it says the defendant repeatedly kept walking back towards the property and eventually walked back onto the property after warning. Can you pull this address? It sounds familiar. I'm gonna get a lot out of that. 599 West Atlantic Boulevard. Pompano. Okay, so what are we doing with this, folks?
Well, Mr. Hunter is anxious to resolve the matter if possible, Your Honor, and we did discuss that it's very important he not go back to this address again in the future, as I explained to him, and as I'm sure he knows, if he keeps going back there, he's just going to keep getting arrested. Right, Curtis?
Yes, sir.
You don't want to have any more conversations with me or the judge, do you?
No, sir.
Okay.
Hey, excuse me, Your Honor. I bet you I have more songs than Kodak before Kodak get out.
You what?
I'm gonna have more songs than Kodak Black before he get out.
Okay. All right, state.
State's offers time served.
Is this a Lorna Wren case, maybe?
If it doesn't plea out.
He resolved a trespass a month ago, so in front of Judge Gottlieb. So
Curtis, you have to stop trespassing.
I know, sir. This the last one. You won't have no problems out of me never again.
Okay.
We're gonna give him, if he wants, I'll do an adjudication 3 days, Broward County Jail with credit for time served. He keeps trespassing. I mean, the officer kept telling him not to go back, and he went back, so.
I know, Judge. The judge is offering you 3 days in the Broward County Jail with credit for time served, Curtis. Are you interested in that?
I can't resolve it then?
You can resolve it, but it would be for 3 days in the Broward County Jail with credit for the time that you've already served.
Yes, sir.
Okay, is that what you want to do?
Yes, sir.
You want to give up your right to a trial like we talked about earlier?
Let me get him to raise
Yeah,
his
I want to give up my right to a trial.
Raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, your name is Curtis Hunter, Hunter.
Yes, ma'am.
All right, put your hand down. You can inquire, Mr. Reedy.
Curtis, you understand you have a right to a trial on this case.
Yes, sir.
Do you want to give up your right to a trial, enter a plea of no contest, and accept the offer of an adjudication 3 days Broward County Jail with credit for time served?
Yes, sir.
Are you sure that's what you want to do?
Yes, sir.
Nobody's forcing you to do it?
No.
All right, we had talked earlier, there's nothing about your medical condition that's affecting your ability to make an intelligent decision today?
No, sir.
Okay. All right, Judge.
All right, you gonna plead no contest to trespassing, occupied structure, or conveyance?
Yes, ma'am.
All right.
Judge, I like your hair, Your Honor.
Thank you. The court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate you 3 days Broward County Jail with credit for time served. Sir, you can't return to the racetrack, okay? $293 in court costs. Thank you. Thank you for all your comments.
Good luck, Curtis.
I got prayers, compliments. All right. Kevin Lovato Jackson, please.
Medical reset, Judge?
Julio Cesar Montoya.
Approaching Judge, he's here at Maine.
Okay, thank you, Mr. Romero. All right, sir, you have, Mr. Montoya, you have 2 trespass, not a structure or conveyance. Bond is set at $1,000 for each count. Anybody wish to be heard?
Judge, in speaking to Mr. Montoya, he wishes to resolve the matters before the court. We'd be asking the court to consider extending offer of adjudication time served in exchange for his plea.
State. I don't have any. Michelle, you got to pull up the arrest reports for the probable cause for, yeah.
State's offer would be time served, adjudication time served, both cases.
Mr. Montoya wishes to accept the state's offer, Judge.
State's offer wasn't over yet. On count 1, or the first case, no return to 200 Northeast 21st Street, 21st Avenue in Deerfield. The second case,
What is that? Where's that?
I just haven't.
Publix is 150.
Yes.
I'm just looking. You're saying 200. I'm just. Because I'm looking at.
Well, that's on.
I see the arrest location because it's 400 North Ocean Drive, actually.
Well, Your Honor, I'm just reading what's here on my system. The no
Okay,
returns.
I'll cover it. So
Okay.
go ahead.
Well,
And then
then,
the Publix.
well, I saw on count 2 is 150 South Federal Highway in Deerfield Beach, and I believe that's a Publix.
Yes.
The first case is 200 Northeast 21st Avenue in Deerfield Beach, and that's Deerfield Beach City Park Pavilion.
Well, in the report, it says 400 North Ocean Drive, but.
Where is it?
All right, so he wants to resolve it?
Yes, Judge.
All right, what's it gonna take to get him to stop trespassing? This is the 4th time at the pavilion.
We'll go back, I promise you, miss.
Okay, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, put your hand down. Is your name Julio Montoya, Montoya?
Yes, ma'am.
All right, it's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication, or ever been
No,
treated
ma'am.
for a mental illness that would affect your ability to understand what's going on here
No,
tonight?
ma'am.
Okay, you agreed to not go back to the Publix in Deerfield Beach, which is 150 South Federal Highway. You
agree not to go
understand?
back there?
Yes, ma'am.
You can't go back there, sir, okay? If you go back
Okay,
there,
ma'am.
you're gonna get arrested. And if you get arrested and I tell you not to return and you come back here again, it's not gonna be a time served, do you understand?
Yes, ma'am.
All right, and so how do you wish to plead to trespass property, not a structure or conveyance, sir?
Guilty, miss.
All right, and that's 2 counts guilty?
Both of them?
Yes, miss.
All right, you agree not to go back to the
Yes,
Deerfield
ma'am.
Beach City Park Pavilion?
Yes, ma'am.
All right, and that's located at 400 North Ocean Drive and 200 Northeast 21st Ave in Deerfield Beach. You understand that?
Yes, ma'am.
All right, the court's going to accept your plea. Find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Court's going to adjudicate you and time serve you on each count, and the court is going to impose court costs on each count of $293. You're not to return, sir, to those 2 addresses. Do you understand?
Yes, ma'am.
All right, you have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Sir, do you need a place to find a place to live or something?
No, ma'am.
Okay. All right, good luck to you, sir.
Good luck, sir.
All right, next one is Leon Laverne Miller.
He's here, President Maine, Judge.
All right, Mr. Miller, you have a capious misdemeanor. You are not to return to the Walmart, sir. 2300 West Atlantic Boulevard, Pompano Beach. You understand?
Yes, ma'am.
What do you think happens if you go back there, sir?
I'm gonna get arrested again.
That's right. All right, bond is set at $500. He was a no-show. What are we doing with this?
Judge, in speaking to Mr. Miller, as the court pointed out, this is from Walmart. I do not believe there's any sort of restitution issues. He's asking the court if you would consider resolving his case today.
State?
The offer that has been documented in my system from the prosecutor's side of the case is adjudication time served.
He wishes to accept, I don't.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth? Right hand.
Oh, I'm sorry. Yes, sir. Yes, ma'am.
All right, Leon Laverne Miller, Miller.
Yes, ma'am.
All right, it's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence? You can put your hand down. Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Okay, you understand that if you get, upon you getting arrested for your 3rd petty theft, they can charge it as a felony. You understand that, even though it's a misdemeanor?
Yes, ma'am.
Did you discuss that with him, Mr. Romero?
Yeah, he told me. I did, Judge.
All right. All right, sir, understanding what I just explained to you, you want to plead guilty, not guilty, or no contest to petty theft with a prior conviction?
Okay, no contest.
Does he have 2 counts or 1? Because it says here on the complaint affidavit, petty theft 1st degree, and then it says petty theft.
One moment.
And it's actually one case number. I don't know why they did it twice. Just this one charge?
Just one count.
All right. So, sir, how do you wish to plead? Guilty, not guilty, or no contest to larceny, petty theft, first degree?
I plead no contest, Your Honor.
Court's can accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Adjudication time served, $293 in court costs. Sir, no return to the Walmart, 2300 West Atlantic Boulevard in Pompano. Okay?
Okay. Yes, ma'am.
Good luck to you, sir.
All right.
You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Lamont Tyro Green, please.
I believe North Broward, Judge.
Sure.
Yes, Mr. Green is in North Broward, and he would like to resolve this case today if
Okay,
possible,
State.
Judge.
State's offer be time served, no return.
Okay, you want to, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, sir.
All right, is your name Lamont Tyro Green, Green?
Yes.
All right, Mr. Reedy, you may inquire.
Mr. Green, do you want to accept the offer of time served? Was it adjudication time served?
Yes.
Would you like to accept the offer of adjudication time served, enter a plea of no contest, and give you up your right to a trial today?
Yes.
All right.
You can put your hand down, sir. Go ahead.
You want me to inquire, Judge?
Yeah.
All right, Mr. Green, is your name Lamont Green, Green?
Yes.
And are you doing this freely and voluntarily here this morning?
Yes.
Anybody forcing you to do this today?
No.
Have you had enough time to discuss your case with me?
Yes.
Do you need to have any more questions of me?
No.
Are you taking any medication that would affect your ability to fully understand the consequences of the decision you're making here this morning?
No.
And this is what you want to do, is go ahead and enter this plea today?
Yes.
All right. I have no further questions of Mr. Green.
All right, sir, you want to plead guilty, not guilty, or no contest to disorderly intoxication, public place, cause of disturbance, and count two, trespassing, unoccupied structure, or conveyance. Guilty, not guilty, no contest.
I believe no contest.
Court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court's going to adjudicate and time serve you on each count. Court is going to impose $293 in court costs on count one. You understand, sir? You can't return to the 7-Eleven, 460 West Broward Boulevard, Fort Lauderdale. Do you understand that, sir?
Yes.
What happens, sir, if you do go back there? What do you think happens?
You're arrested.
All right, so don't go back there. Thank you, sir. Good luck to you. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Thank you.
Okay.
Next person is Jose Negron, please.
Judge, I think we skipped the Baptiste, Jean Baptiste.
All right, I don't know what happened. Oh, no.
Count is here at May, Judge?
Oh, we need a Creole interpreter for him.
Creole?
Just pass.
Yes, for Mr. John Baptiste, they should be one on their way, Judge. I
All right.
called earlier.
Jose Negron, please.
He's here at May, Judge?
Thank you, Mr. Romero. All right, Mr. Negron, you have a warrant for $250 for operating without a valid license. State, what's your offer on this?
Withhold court costs.
I'm sorry?
Withhold court costs.
Hold on, I couldn't hear Mr.
Withhold court costs.
Withhold and court costs.
He wishes to accept.
Raise your right hand. Do you swear and/or affirm to tell the truth, sir?
Yes, ma'am.
All right, put your hand down. Jose Negron, Negron.
Yes, ma'am.
Okay, it's my understanding you wish to waive your right to a trial.
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
You under the influence of any alcohol, drugs, or medication, or ever been treated for a mental illness?
No, ma'am.
Okay, how do you want to plead? Guilty, not guilty, or no contest, sir? 2, operating without a valid license.
No contest, ma'am.
Court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court's going to withhold adjudication and impose court costs. The court will take judicial notice of the time that you served in the Broward County Jail. The court's going to impose court costs of $293. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir. Next one is John Carl Newsom, please.
Medical reset.
Okay, next one is Okay, next one is Orlando Don Henry, please.
Could we reset him for tomorrow, Judge?
Sure, why?
He refused, but it's a misdemeanor. Maybe tomorrow he might be in a better mood and we can resolve it.
Okay, reset for 5/8 in the AM.
Judge,
Thank you.
just to let you know, he's been arrested since the 4th.
He's been what?
He's been in custody since May the 4th. Today's the 7th.
All right, you know what? I'm not gonna reset it. State, what's your opinion on this? What's your position?
One moment, Your Honor. Where is-
Defendant refused and voluntarily absented himself.
I don't know what happened over the weekend, because it looks like he was reset from the 5th and the 6th, from Saturday and Sunday. I don't know if those were refusals, if there was a medical issue involved. So while I am told that he did refuse today, without more information, I'd ask that he still be put on for tomorrow morning, Judge.
Your Honor, he refused today. I'd ask that the court make a PC determination, keep the bond in place, and then he'll be brought back on a second look, I imagine.
Well, we can just
He was
reset him
trying-
for,
He was trying to steal a piece of cheesecake and beer. I mean, the jail is not, and I know, you know, we discussed this before, it's not a hospital, and, you know, it's not a shelter. So there's plenty of resources we can offer him if you want to talk to him. This is what I'm gonna do. I am, going to find that he refused and voluntarily absented himself. I'll give him, maybe someone can speak to him, I'll reset for 1 PM today to give him time to come here, okay? I will find probable cause, but Madam Clerk, if we could reset him for the PM, okay? And we can talk to him about going to the Central Receiving Center or somewhere. But, I mean, just to have him sit in jail is, you know, not good. Doesn't resolve anything. Peter Mark Anthony Blackman, please.
He's here at Main, Judge. He's approaching.
All right, good morning, sir. How are you?
I'm okay, Judge.
All right. All right, sir, you have a robbery by sudden snatching with a firearm or weapon. We need to talk about bond. You also have count 2, touch or strike battery. Any objection to probable cause?
this is kind of a very strange probable
It's a
cause
roommate's.
affidavit, and it's very short.
Yes.
So we really don't have a lot of details here, but I'm not so sure that I see a robbery with a weapon. It looks like they're fighting over this woman's cane, and I guess they're grabbing it back and forth.
Well, it started, they were having a fight, I think, over the rent.
Yeah, I
That
think
was
so.
my memory.
According to the report, yes.
Made contact with 3 roommates.
And Mr. Blackman's accused of grabbing the walking cane from the alleged victim, and then she grabbed it back from him and swung at him, and it sounds like quite a commotion. And then all 3 of them were fighting over the cane, and then the victim was able to regain control of the cane.
Someone came back with 2 sticks.
Yeah, Mitchell emerged from the room with 2 sticks in her hands like karate. When she heard, I don't even know what that means. I mean,
Like a karate move.
well, I guess so. I don't know, Judge. It doesn't really sound like that robbery with a weapon. I mean, it just doesn't have that ring to it. I would say that there's no probable cause to establish that charge, and if the court disagrees with me, I'd ask you to keep it in consideration when bond is posted, or what type of conditions of Mr. Blackman's release are contemplated by the court. But it's just, I'd like to know a lot more than what I'm reading here.
Your Honor, I believe that there's probable cause for just robbery by sudden snatching. He's out on bond right now in an open,
With the firearm or weapon?
no, without just robbery by sudden snatching. He's out on bond right now in a pending resisting without violence. Requesting $1,000 bond on count 1, $1,000 bond on count 2, order of no victim contact.
about the ability to go back with law enforcement to obtain his belongings.
Yeah, of course, that's fine.
Okay, what's your position, defense? 1,000 on each.
Judge, normally I would be okay with that considering what the alleged, I guess, allegation is as far as the charge itself. However, in speaking Mr. Blackman financially, he's not going to be able to post that bond. Mr. Blackman this morning has spoken to me quite a bit. There are two sides to the story. I believe the initial aggressor, the landlord, of course, complaining of the rent not being paid. My understanding is, Judge, and this will bear out through the facts and eventually at trial, unfortunately, landlord took kind of the law into her own hands, and she had the cane and was using it on Mr. Blackman as a way to defend himself. That's when he actually obtained the cane. But having said that, Judge, like my colleague said, there's a lot of information on the PC that's just left out, and that will be for a later date. And speaking Mr. Blackman, I did advise him, most likely the court's going to impose a no contact order. He's not going to be able to return there. I do appreciate we're going to be asking him to go back one time with law enforcement to retrieve his property. He's 39 years old. At this time, he's looking for employment. He had an actual job interview scheduled for today. Unfortunately, he lost it. There's no one that could go ahead and post his monetary bond. Judge, he's at this point, I don't know where he's going to be living or residing, but financially, he can't post any sort of bond. So I'd be asking you to consider releasing Mr. Blackman on pretrial release. I do understand that he's out on the case, but it's a misdemeanor offense. I don't think he has an egregious criminal record. So, Judge, I'd be asking you to consider releasing him on pretrial release.
All right, this is what the court's going to do. No victim contact, direct or indirect, sir. You can go back to the home one time with law enforcement to obtain your personal belongings and property. Court's going to find PC for robbery by sudden snatching only on count 1, no weapon or firearm. Count 2 is touch or strike battery. Bond is 1,000 and 100. Thank you. Good luck to you, sir, okay? Patrick Monroe Mullis, please.
Sorry, which one is 100? Count 1?
No, count 2.
Count 2 is 100.
The
Count
touch
1.
or strike battery, the misdemeanor is $100.
And then count 1.
Yeah.
So, Judge, count 2 is 100 and count 1 is 1,000, you said?
Yes. Okay. All right, Patrick Monroe Mullis, please.
Mr. Mullis is here, President Main Judge.
Good morning, Mr. Mullis. You have petty theft, second degree, third subsequent offense, bond set at $750. Court does find probable cause. Hold on. Court's going to order no return to the Walmart, sir, located at 5001 North Federal Highway, Pompano Beach, Florida. Do you understand?
Yes, Your Honor.
You understand? Hold on. Do you understand?
Yes,
What happens if you go back there?
Yes, ma'am, I do. Yes, Your Honor.
What happens? You'll get arrested.
I believe there's no probable cause. I went in the store in the hygiene aisle, and they said that I took something, but I didn't. I came out to the
Sir,
door.
do you see you have an attorney next to you?
Oh, yes, ma'am.
Okay. He's telling you not to talk about the facts of the case. So if you want to talk about the facts of the case, anything you say can and will be used against you. So we have petty theft, second degree, third subsequent offense, $750 bond, no return to the Walmart. Anybody wish to be heard with regard to the bond?
Yes, Judge. And speaking of Mr. Mullis, he's going to be requesting a straight ROR, and this is the reason why. We do understand, as a petty theft, we do understand he has a record. Unfortunately, for Mr. Mullis, he's not in a financial position to post his bond. From what he informed me, Judge, he will have his day in court. I did tell him today is not the day to present his side of the story. However, in saying that, Judge, the merchandise was not recovered on his person. From what he advised me, once he was arrested, he went back to the store, to the loss prevention office. They went ahead and reviewed the video. On the video, it doesn't show him taking anything. So I did tell him he will have his day in court to present his side of the story. Judge, he's adamant as far as his innocence. He does not know why. I guess loss prevention is claiming that they saw him steal any merchandise. He's adamant that he never stole this merchandise. They kept on telling him he stole razor bait, have him confess. He said no, he was adamant as far as his innocence. Judge, he's asking for a straight ROR on this case.
Well, what I find interesting is it says in the PC, it says with the listed items, which consisted of razors, and then it says the total items were $219. So unless there were other items other than razors, I don't know how razors cost $219, but
Your Honor, razors sold and they can actually be quite expensive. They can be.
okay. Okay, the
Judge,
court
and
finds
also in the
probable
PC,
cause. Any further argument, State?
Your Honor, just bring it to the court's attention. 12 prior felony convictions, 39 prior misdemeanor convictions. He just got off probation on multiple felony thefts January of this year.
Okay, defense, 4065 Southwest 22nd Street.
Is that your address, sir? Yes.
Of course, one package doesn't cost $200, but they're not cheap.
Hey, and that's in Fort Lauderdale, right?
Yes, ma'am.
All right, because they have it spelled wrong here. All right, no return to the Walmart, sir. Standard pretrial release. Thank you, sir. Good luck to you. You have to report within 24 hours. Madam Clerk, they spelled Fort Lauderdale. They spelled it wrong, so you just have to update the F in the Fort, okay? All right, Sean Lawrence Wright, please. Then after that, we have Chadrick Lofton. Are you Mr. Wright, sir? All right, good morning. You have count 1, 2, possession of weapon or ammo by a convicted Florida felon. Count 3, attach a registration license plate not assigned, $25 bond. Actually, on counts 1 and 2, we're going to discuss bond. Count 4 is grand theft of a firearm, $1,000 bond. Counts 5, 6, 7, and 8 are possession of weapon or ammo by a convicted Florida felon. We need to talk about bond, and same for count 9. Any objection to probable cause?
Yes, Your Honor. Regarding count 4, I did not see anything in the probable cause affidavit that would indicate Mr. Wright stole this firearm.
State?
It's fine, Your Honor.
Okay, so no PC for count 4.
Also, Judge, it appears as though, I'm sorry.
ROR him, then on count 4, go ahead.
On counts 7, 8, and 9, it appears as though they charged Mr. Wright for each bullet.
Yeah.
So I would ask the court if a finding of probable cause is to be made. Count 5 could be as to the weapon. Count 6 could be as to 1 bullet, 1 ammunition. I'd ask the court to ROR Mr. Wright on counts 7, 8, and 9.
Okay. State?
Your Honor, I'm asking on count 1, 10,000, count 2, 5,000. I am concerned that he's even in possession of a firearm and ammunition. 2014 had a grand theft. 07, which is the base for my concern, and it's mentioned in the report, he was convicted of robbery with a firearm or deadly weapon.
All right, Mr. Romero.
Judge, I think we're in agreement as far as counts 3, we're okay with the standard bond 25, 4, no probable cause. And I believe from what Mr. Lender, he's not asking for anything on 5 through 9, so that would be an ROR. So the only counts that we're here to discuss are 1 and 2. Judge, and speaking, Mr. Wright.
I don't think, I don't, Mr., you're asking for, you said an ROR?
No, Your Honor, I'm fine. 1 and 2 are the first possession of weapon or
Okay.
ammunition by convicted felon counts. I'm fine with count 1 being for the firearm and count 2 being for the ammunition.
Okay, and what about
Then I'm fine with ROR and the rest.
5, 6, 7, 8, and 9, right?
Yes.
Hold on, give me one moment. Okay, all right, go ahead, Mr. Romero, I'm sorry.
Judge, what we're going to be asking the court to consider is on count 1, $2,500 bond, and on count 2, $1,000 bond. Judge, he's 29 years old, been living in our community his whole entire life. He currently has 2 jobs. One, he's a barber. He does full-time. He's been doing that for about 4 years. He makes on an average about $80 per day. Number two, now he has a 9-month-old child, so he went ahead and got a second job. He works for a company called Carrier Express. He just attained that employment. It's part-time. He makes about $150 per week. He's a sole provider of his family, his fiance. His fiance is currently caring for their 9-month-old child. They live in Fort Lauderdale. Judge, at this time, he believes that his fiance can come up with a $3,500 bond on counts 1 and 2, and that's the basis of the reason why we're requesting $2,500 on 1 and $1,000 on 2, Judge.
All right. This is what the court's gonna do, 3,500 on 1, 1,500 on 2, ROR 3 through 9. Thank you very much, sir. Okay, Chadrick Lofton, please. Come on up, Mr. Lofton. Good morning, sir. How are you?
Morning.
All right, Mr. Lofton, you have a robbery with a weapon. Court does find probable cause. State?
Yes, Your Honor, it's a robbery with a deadly weapon. I am going to be seeking a no bond hold upon a finding of proof evident or presumption grade. And, Your Honor, I think taking all the evidence together for first appearance purposes, there is proof evident or presumption grade, considering the victim's identification, his probation officer's identification, and the cell phone evidence indicating he was in the area at the time of where the robbery was committed at the time it was committed.
This is a Metro PCS store?
Yes, ma'am.
All right, Mr. Reedy, you want to comment on proof evident presumption grade?
I do, Judge. Proof evident presumption grade is the highest standard that we have in our criminal justice system, and the state has provided the court with a warrant regarding Mr. Lofton as their only means of attempting to reach that very high standard. Our position would be that they have failed to do so, and that Mr. Lofton should have a bond set. The victim in the case indicates that she would be able to identify Mr. Lofton if she ever saw him again, and yet when she's shown a photograph out of a photographic lineup, she's only 80% certain that the photograph she viewed was Mr. Lofton. Well, not only is that not proof evident presumption great, that's not even probable cause. So I would say that the affidavit and the warrant fall short of that very high standard. Yes, the cell records indicate that Mr. Lofton's phone may have been in the vicinity. It does not indicate that Mr. Lofton was in the vicinity. And we don't have any testimony here from his probation officer as to the set of circumstances surrounding her identification of Mr. Lofton. So absent those things, Judge, we would submit that the state has failed to establish proof evident presumption great. We would ask the court to set a bond for Mr. Lofton.
Okay, the court notes it says in the affidavit to arrest, Affian spoke with Lofton's former probation officer. Affian sent her the news release of the Metro PCS store and the video clip of the armed robbery subject. She advised that the subject appeared to be her former client. Therefore,
appeared to be, Judge. Not that's him. It appeared to be. So we have some very questionable identifications, both from the victim and from the probation officer herself.
okay, the state?
Your Honor, and that's why I argued taking everything together, and even 80% certainty with the probation officer identifying, and then the cell phone evidence, Your Honor, I think taken together, I think satisfies proof evident or presumption grade.
All right, I have reviewed the warrant to arrest affidavit and other documents in your case, sir, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, sir, you're going to be held without bond on this robbery with a weapon charge until further order of the court. This is without prejudice, sir, for you to file a motion before your division judge and request a hearing under State v. Arthur, and that's basically a hearing, sir, to request a hearing to set bond. You're to have no contact and no return, sir, to the Metro PCS store at 2312 West Oakland Park Boulevard. Do you understand, sir? Thank you very much, sir. Good luck to you. Okay, David Markhill, please.
Going to be a medical reset, Judge.
All right, what's going on with him?
I don't know. He was there, and they did have him ready to go this morning. So I guess he's getting closer. So at least we made some progress from the last few
All right.
times.
Maybe next time we can call him first and you can check and see.
Yeah, I was going to call him first, but they called me back before we even started, so.
All right. Let me just know next time. I'll take them before the detox.
Yes, ma'am.
Okay. All right. And then Frank Battles.
He's approaching, Judge.
All right.
Our Creole interpreter is also here, Judge.
All right. Come on up. Are we taking Frank Battles or?
Yes, Judge. He's coming up right now there.
You
He's
know
in a
what?
wheelchair, Judge.
Let's do the, hold on. We have the Creole interpreter here, though.
Yes, sir.
It's on court's docket. He is in North Broward.
Okay. Raise your right
And it's a
hand,
municipal
swear
ordinance
in
case.
Or affirm to translate from English to Creole, Creole to English.
I do. Chantal Bazelet, B-A-Z-E-L-A-I-S.
Hi. Thank you. All right. Are you Mr. Jacques Jean-Baptiste, sir?
Est-ce que c'est Monsieur Jacques Jean-Baptiste, monsieur?
Oui.
Yes.
All right, sir. You are charged with one count of unlawful assembly.
Monsieur, il a accusé, il a fait un charge sur vous, ou t'as fait un meeting qui pas légal. I wasn't doing anything. I was sitting on a bench. Monsieur, quittez, bon mon petit temps pour me ça traduire. I was sitting on a bench. Dis non. Dis ce que t'as dit.
Ok. Il va te sur dans la place en rien qui va ça. C'est une station boss, c'est l'âme dormi, c'est l'âme chita, c'est l'âme passer là, plus là, il y a la prime quoi, l'hôpital là, mais il va arriver.
Okay, Tan. I was just sitting on the bench. That's where I sleep. That's where I stay. And when it rains, I go inside the hospital. Allez, continuez.
Oui. Police là, c'est vrai, il va venir même côté moi.
The policeman just don't want to see me.
Il va venir web, côté web. Tout l'idée c'est pour l'arrêter, pour que monsieur, son grand monde moyen.
They don't like me.
Son monde infime moyen. Police là, c'est dit pour ta protection, tu manger pour qui ça c'est lui. T'as bon problème, ça tu pas capable même.
Okay, Tanati Moma. The police seem not to like me. They look for everything so that they can arrest me.
All right. Do you have a place to live, sir?
Est-ce qu'on côté pour habiter, monsieur?
C'est un monsieur qui cherche un caille pour louer, mais il peut pas trouver une machine.
It's somebody who is looking for a place to rent. But he hasn't found it yet, so he gave me a car so I can sleep in it.
All right. These are his options.
Mais qui choix qu'on gagne?
He can either pay $100 bonds.
Est-ce qu'on va payer un bon de $100? I can't even eat. I can't even pay for my food. I have no money. I don't even have $1.
Well, the problem is he keeps failing to show up at court.
Problème là, c'est que ou pas venir dans le tribunal là, là, il y a rendez-vous.
He keeps trespassing.
T'as un moment, monsieur. Yes.
He keeps trespassing and he can't go back to this hospital.
Ou aller dans des côtés qu'on pas supposé rentrer. Ou pas gain droit retourner dans l'hôpital ça.
I mean, if he's going there as a patient, he certainly can go to the hospital.
Si ou a un problème et que ou aller en compassion, ou monde qui besoin de soins, là ça ou gain droit aller.
Or he has a legitimate
Tan.
Hold on.
Tan, monsieur. Monsieur Tan, pas parler en même temps à juge là. I'm just telling him not to speak at the same time you are judge.
Thank you. Or he can go there if he has a legitimate purpose.
So gon raison qui fait quoi dans l'hôpital là ou gain droit aller.
But it's not because it's raining out.
Didn't hear you. Somebody was talking at the same time.
Okay, he certainly can't go there if it's raining out just to, get shelter from the rain.
Si c'est juste que ou pral pari la pluie, ou pas gain droit à là. C'est seulement sous besoin de soins que pour ou capable aller.
this is the situation, sir.
Donc, ma situation, monsieur.
You're denying that you committed this offense.
I'm sorry.
You're denying that you committed this offense of unlawful assembly.
Est-ce que ou dit que ou pas fait aucun ou pas fait aucune réunion qui pas légale?
So,
Son gros moun moi aime pas un garçon mais moi marche pas ka marcher. J'ai tout douleur dans corps moi. Il est malade. N'a qui des autres pour me d'ailleurs.
Nothing. I didn't do anything. I'm an old person and I have a problem with my feet. In what kind of uprising could I be into?
all right, I can say, sir, would you like to avail yourself of services where they could possibly find you a place to live?
Monsieur, est-ce que tu aimerais que nous recommandions dans un service côté que tu es capable de joindre un côté pour ta habiter? I have somebody who is looking for a room. Somebody is looking for a room for me, and he's going to do it.
You know what? Court's going to keep the, let's make a copy of this. We're going to keep I'll do standard pretrial release.
I'm sorry, Judge, I couldn't.
Standard pretrial release.
Yo pral lage ou dans ça y aurait un pre-trial release. Ça veut dire que yo pral lage ou pour un temps avant qu'on retourne dans le tribunal là.
Sir, how are you going to find out when your next court date is?
Monsieur, comment on fait connaître qui prochaine fois obligé venir dans le tribunal là?
Comment on fait connaître?
How will I know?
Il gon adresse à l'Elio, juge la connaît. L'Elio on gon qui kon c'est là il qu'on écrit.
There is an old person who used to write to me. The judge has the address, but I don't know it myself.
All right, you know what? I'm going to refer this to Judge Wren.
OK, m'bral voyer ba ça à joindre nous le juge.
Court's going to keep the $100 bond in place.
OK, et puis nous pral kembe que c'est pour un bon $200.
State, is there any way that you can just send this gentleman to Judge Wren?
Done.
Just notify her?
Sure.
L'État est nous conjoint que nous
Appreciate it, thank you.
nous sommes capables de garder pour notifier monsieur ça.
All right, thank you very much.
OK, merci beaucoup, monsieur.
Thank you, sir. All right, next one is Frank Battles, please. Sorry about that, Mr. Romero. All right, sir, you have a possession of cocaine, $1,000 bond. Court does find probable cause. Anybody want to be heard with regard to the $1,000 bond? Oh, thank you.
Yes, Judge. Mr. Battles, he's 62 years old. He's on disability, getting about $750 per month. He lives in Fort Lauderdale. His roommate charges him about like $500 a month to live there, so he basically has $250 to survive. He has no sort of savings. Nobody's going to be able to post his bond. He's going to be asked to be released on pretrial release.
State?
Your Honor, as far as his failures to appear, he was arrested in March on a capias. Then he was picked up in January on new charges, and there was also an active capias for failure to appear at that time. Another capias last year. Arrested in 2013 on a warrant for violating pretrial. He had to be taken in on a court order in 2012. Another capias in 2012 on a domestic violence. He had court ordered into custody 2008. On top of that, I see out of Broward alone, he's been sentenced to prison on 14 different criminal charges in the past.
What kind of criminal charges?
possession of cocaine, robbery, strong arm robbery, aggravated battery, resisting with violence, obstruction.
(624) Northwest 15th Terrace.
Is that your address, sir?
No.
No? What's your address, sir?
My address is 1616 Northwest 7th Terrace.
1616 Northwest 7th Terrace, Judge? And it's a house or apartment?
Apartment.
Apartment. Is there a specific apartment number on it? Apartment number 1. And what city is that in, sir?
Florida, Florida.
And do you know the zip code?
33311. I don't know when you come on armed
Hold on.
robbery. Never been arrested for armed robbery at all.
Judge, his address is 1616 Northwest 7th Terrace, and that is in apartment number 1 in Fort Lauderdale, and the zip code is 33311. As far as the priors that Mr. Lender has read off, he's disputing the robbery. He doesn't remember, call it, or anything like that.
He said he's never been convicted of armed robbery. I said he was convicted of strong arm robbery.
No, he doesn't remember the strong, what year was that?
It was an 87 strong arm robbery, aggravated battery with a deadly weapon. He was sentenced to 87. He was sentenced to 7-year state prison.
Okay, what are you asking for, Mr. Romero?
Judge, we're going to be asking for pretrial release. It's a drug offense. There's no one that can post his bond. I know he says he has health problems. He suffers from seizures, Judge. I'd rather have him home. So we're asking for pretrial release, Judge.
Well, the issue is it sounds like he doesn't show up for court. When was his last prior contact date? What year did you say it was?
He was arrested March 3rd of this year. That was on a capious municipal ordinances for paraphernalia and resisting without violence.
He's saying that as far as the court date, Judge, he was unaware. He never received notice on that.
Right. Court's going to keep the bond at $1,000. Thank you.
Yes, Judge.
All right. All right. We'll see you back at 1.
Said let him go to SAP and get some help. He won't use it.
Oh, wait. Yes. John Newsom, medical reset.
Yes.
I don't know, Michelle. What page? John? Huh? 11.
Medical reset.
Yeah.
John Newsom. Oh, North Broward.
Okay, Michelle, you gotta write bigger. Are you kidding me? Okay. See you at 1.